Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment, it was forged by law within a unique justice system born from the union of the civil law and common law and increasingly indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments. Justice Rowe, thank you for joining me. As the Supreme Court of Canada celebrates its 150th anniversary, it's a fitting time to reflect on the institution and the people who shape it. Your appointment in 2016 was a historic moment as you became the first justice to sit on the court from Newfoundland and Labrador. Your path to the bench is anything but conventional. You've estimated that about 40% of your career was spent on non-legal roles. You started as a procedural advisor in your province's House of Assembly, a role you've humorously described as being one of the penguins in the middle with the best seat in the House. You served as Foreign Service Officer before entering private practice. Even then, your work in private practice was at the center of major national issues. You were deeply involved in arbitrating the maritime boundary between Canada and the French islands of Saint-Pierre and Miquelon, a dispute over valuable fishing grounds that ended with a decision you described as very much in Canada's favor. A few years later, you were a central figure in Canada's response to another crisis, the overfishing by Spanish vessels that threatened the collapse of turbot stock in the Grand Banks. In your own words from your judicial questionnaire before being appointed to the Supreme Court, under the directions of then Fisheries Minister Brian Tobin, you formulated the strategy for the Turbot War, a high-stakes plan that blended international law with the dramatic arrest of a Spanish vessel on the high seas. Perhaps more remarkably, before you were a judge, you played an instrumental role in changing the constitution of your home province by coordinating the successful amendment to create a secular public school system. You have been a nation builder, a hands-on person. Justice Rowe, with a career spent not just interpreting the law, but actively shaping it from the legislative, executive, and diplomatic branches, how does this wide-ranging experience inform your approach to the complex cases that now come before you as a judge?
My experience before going to the bench, notably in criminal law, which is very important for the court, because I didn't have any experience with criminal law before I went to the bench. Since I've been on the bench, I've focused a great deal on criminal law, and I think I've learned a great deal about it over the past, 27 years since I've been a judge. What I would say, though, is that on public law issues, on constitutional matters, on administrative law matters, on the use of international law, all of those have been informed by my understanding of the operation of government and the consequences of our decisions and the decisions of various courts throughout Canada on how the institutions of the state operate. The legislature, the cabinet level, the bureaucracy, and how all of that also relates to international institutions, the United Nations, specialized agencies, etc. Because I've been there. I've worked in those organizations. So I can draw a direct line between the kind of decisions that judges make and the consequences for all of those other actors and institutions in the political structure of the country.
Is it something that your colleagues might ask you? How does it work in real life, if I can say?
I'm not sure they ask me so much as I tell them anyway. No. And in the end, the decisions of this court, as with any court, had to be taken in accordance with legal principle, proper legal methodology, and the like. And yet, judges should always be mindful of practical consequences. Mm-hmm. That's part of our role. It's not divorced from it. You need to put together a sense of practicality with the application of principle. And so I bring a little bit on the practical side, at least in the public law area.
What is the crucial element that transforms a private disagreement into a legal dispute that gives the court a legitimate reason to intervene or to get involved?
In liberal democratic societies, Canada, the United Kingdom, France, South Korea, whatever, what you have is people making voluntary decisions and in cooperation with others to order their own lives. People do this. The simplest example is one's family. But ordinarily, the state has no role in the ordering or the structuring of family relationship. Of course, if there's abuse, if there's neglect, there's an element of, say, of cruelty or economic unfairness, particularly when a marriage breaks up. You have to hold people responsible towards their children and the like. Pierre Elliott Trudeau said that the state has no business in the bedrooms of the nation. Well, I don't think the state has much of a role around the dinner tables of the nation. And so if you take that basic idea that individuals voluntarily coming together order their own affairs and that the state should not intervene or supervise that, if that's of importance to you, then the line between where the state makes rules which structure how you live your life and what is left solely to you, that's an important line. And it has a particular significance when it comes to religious organizations because the division between church and state is something which is absolutely fundamental to Western liberal democracies. It is not so perhaps in other cultures, particularly historically, where there was a unity between religious authority and political authority. And some countries and cultures wish to organize themselves that way. That is not how we do so. And so being mindful of this division between what is purely private and is outside the public sphere and what is regulated by the institutions of the state, by the rules of common law, by statute, and which is therefore subject to dispute, and where there is a dispute on legal matters, ultimately the resolution of that dispute through the courts. You need to trace a line, and you have to be mindful of that line, and that's what the court did in Wall and Jehovah's Witness, and it was unanimous. I was in accord entirely with my colleagues.
I'd like to turn to another significant case you were part of in 2022, R.V. Kirkpatrick. We're not going to discuss directly the case. It dealt with consent in a very modern context. A woman agreed to have sex with Mr. Kirkpatrick only on the condition that he wear a condom. He did so the first time, but not the second, a fact she only realized after the act was over. The question for the court was whether this amounted to sexual assault. While the court was unanimous in the result, ordering a new trial, it was deeply divided in legal reasoning. The majority created a new framework for this specific situation. However, in the concurring reason you co-authored, you argued that the court was bound by a previous decision, a fundamental doctrine you explored in detail called the stare decisis. You wrote that stare decisis means to stand by previous decisions and not to disturb settled matters. You explained this principle is crucial for three reasons. It promotes legal certainty and stability, it promotes the rule of law, and it promotes the legitimate and efficient exercise of judicial authority. Could you unpack why this principle of standing by decisions is so vital?
There are several points. The first one is, in some legal systems, the use of precedent of earlier decisions as establishing rules which are then to be adhered to subsequently, it is not given the importance that it is in the common law world. And the common law world would include Canada, the United Kingdom, Australia, New Zealand, the United States to some degree. But when it comes to criminal matters, at least, there is no division because there is one criminal law for Canada. But in terms of the civil code, Precedent does not have the same status. It's part of how our system is structured. So we should faithfully adhere to the institutional structure in which we operate. The second one is that there are very strong policy reasons for adhering to stare decisis. And it comes back to people knowing what the law is in order to order their affairs properly, to make autonomous decisions as to their affairs. If the law could change sort of overnight, or simply because another court was asking the same question and answering the same question, people would not be able to have confidence as they proceeded. And so a certain amount of predictability is a very good characteristic, an important characteristic of any effective legal system. And the final point I'd make is that adherence to a coherent methodology which is consistently applied is in fact an obligation of the court so that they use their authority legitimately. Our authority shouldn't be used ad hoc. It isn't about my personal preferences. I have the authority, but I must exercise it in accordance with the methodological constraints. And so the legitimacy with which I utilize the authority is a reflection of my adherence to the proper methodological constraints which attach to the authority. That sounds a little abstract, but it means that the judges have to play by the rules. They can't just make it up as they go along.
Are there any conditions that would permit the court to go against the stare decisis?
Yes, and one of the things which was brought out in a mere 30 pages or so in Kirkpatrick was a very extensive review of what the court has said in about the last 40 years as to the circumstances in which it should properly depart from its earlier precedents, because the law cannot remain static. If the law remains static while the society changes, law then fails to fulfill its function in terms of assisting in the operation of the society. You have to remain contemporary, thus there needs to be the ability to develop and adapt, but you also have a degree of stability, so you have predictability and an orderly development of things. And so where two instances that come to note from what we set out as to when the court should depart from its earlier precedents is where an earlier rule, an earlier precedent, has proven itself to be unworkable in practice. It seemed like a good idea at the time, but it just isn't working. And so rather than doing the same thing again and again, which is problematic, you need to revisit it and see if you can formulate something which is both in accordance with principle and, as a practical matter, is functional. And that's the first one. And the second one that I would mention is that all of these rules, perhaps in an indirect way, but in a very meaningful way, relate to the structure of society, how people deal with one another, how the economy is structured. What are the expectations of people as to their society? What are their aspirations? And so where the underlying social conditions which were at the foundation of an earlier rule, have shifted, then the law must adapt to be consonant with contemporary society. Sort of fundamental societal change is a sufficient basis to review precedent, not a blip from one year to the next, and something of a more fundamental nature than that.
From Morgenthaler to Daigle-Tremblay, from Rodriguez to Carter.
Yes.
So that would be societal change that triggered those.
In terms of Rodriguez and Carter, when you read the reasons of this court, I took away two things of great significance. The first one was that in the Rodriguez case, where the court had said there is no protection under Section 7 of the Charter for the right of an individual to be assisted in ending their life when they're terminally ill and suffering. The first point was that there was a very well-founded, I think, concern that any system would be misused and that vulnerable people might be, in a sense, taken advantage of at a time when you really don't want that ever to happen, right? And there was international experience, particularly in Europe, places like Switzerland,
correct,
which demonstrated that you could put in place a system which fulfilled the objectives of giving the person who was suffering with a terminal illness an opportunity to make an autonomous choice with the safeguards against the misuse of that. That was the first one. And the second one was that the attitudes of Canadians had fundamentally changed. The court can't be in the business of doing polling and saying what's popular today, that's what we'll decide. But I think it is relevant to have regard to what Canadians feel is morally acceptable and morally proper. And there was quite a remarkable change in the attitude of Canadians. That contributed to the decision.
I understand the court is not polling the population, but how does it get the pulse of the population to notice that society has changed? Do you simply read the paper? Or how does that work?
I think it's more indirect, and it isn't exactly new, right? The Persons case, 1930, around that period, it was a decision of the Judicial Committee of the Privy Council. What the case was about was whether women were eligible to be appointed to the Senate. And the word person was used in the Constitution Act 1867. And the Supreme Court of Canada said women were not eligible because in 1867, that word was understood to only to refer to men in the context of service in Parliament. And that decision of the court, the Supreme Court of Canada, saying women were not eligible, was then appealed to the Judicial Committee of the Privy Council in London. And Lord Sankey said, look, this is 1930, get with it, right? Times have changed. It's not 1867 anymore. And he was right, and things have changed since 1930. So there's these sort of deep societal patterns of change. You don't do polling, but you live in the society. You have a sense that things are different now than they were 50, 80, 100 years ago. And it is entirely proper for judges to be mindful of that because judges, we're supposed to be independent, we're supposed to be impartial, but we have to be, in a sense, connected to the society to fulfill our responsibilities.
As the court looks ahead to the challenge of the next 150 years, issues that past generation of judges could never have imagined, the nation will rely on the court's wisdom, guided by its history, stare decisis, from this unique vantage point. How does the court draw upon its deep well of past decisions to navigate the novel and complex national issues of the future?
I'm going to refer to two cases to illustrate how I think that while the court's decisions and the whole body of law must adapt to the society, there are some underlying foundational arrangements and principles which we have to maintain, or else we depart from the fundamental enterprise of Canada. And one that comes to mind is the anti-inflation reference. In 1976, the Trudeau government brought in anti-inflation legislation which regulated wage and put in place wage and price control. And the question was, did that interfere with property and civil rights within the province? Something which is given to the exclusive jurisdiction of the legislatures of each of the provinces. There was a great testing in the reasons for decisions. There were two champions faced off against one another. And one was Bora Laskin, the Chief Justice at the time, who carried forward a certain view of a strong centralized government. And on the other side was Jean Betts, who was a great scholar and a great jurist, and really, perhaps, I would think, in modern times, the leading scholar in terms of federal-provincial division of powers. And he took a traditional view, particularly the traditional Quebec view of the division of powers. And Laskin said, and I'm going to characterize it and perhaps distort it by simplification, in order for the country to proceed, certain authority must be held and exercised by the federal institutions, especially the Parliament of Canada, or the country cannot succeed in times of great difficulty. And the 1970s were a time of great difficulty. Jean Betts said, yes, but if we exaggerate this, if we too readily say that there's an urgency which requires the national government to make all of the important decisions, what will happen is that the authority, the legislative competence, which has been given exclusively to provincial legislatures, will be diminished to the point where it essentially the Confederation bargain will be rewritten, and we will depart from a certain, to a fairly significant degree, decentralized pattern of confederation to something which is far more highly centralized. And so, to me, the particular outcome of that case was less significant than the classic statement of those two perspectives and the trade-offs that are involved. When you look at it, the national perspective and the importance of dealing with exigent circumstances, perhaps, and on the other hand, the need to maintain exclusive authority within each province to shape their society in a way that is meaningful and is not effectively subordinated to some national view.
I like to study the justices prior to each interview, and I got to say that this decision was pretty niche. I wouldn't have found this one, but you did say that you had two cases.
I think that aside from the Charter and aside from Aboriginal and treaty rights, because there's a number of very, very significant cases there, the other case would be the Secession Reference. Yeah. And the Secession Reference really spoke to, well, a number of things, but two things in particular for me. It's what is the nature of the federation, and how do we resolve our differences? And if we cannot resolve our differences on very fundamental matters, how then do we deal with the prospect of the nation no longer existing as a unified country, which is, as profound a question, I suppose, as you can have. And I thought there was tremendous wisdom how the court framed that question about national unity in the future of the country. The other thing, which was of great significance for me, and perhaps would be focused on less by others, was that in arriving at a way of saying, here is how the question of whether, in particular, it was Quebec, would choose to leave Canada, and how would that decision properly be taken, and what would follow from a referendum result which gave a clear answer and a clear question saying, we're going to go our separate ways. There was wisdom in resolving that, but along the way, the court had an overview of all of the constitutional arrangements which make up the Constitution of Canada. They referred to the Constitution Act 1867, which used to be called the British North America Act, the Constitution Act 1982, which notably contains the Charter and other things. It referred to constitutional conventions, the rules by which authority is exercised in practice. For example, the Constitution doesn't even refer to the Prime Minister. And yet, who is the most significant figure in the Canadian government? It is the Prime Minister. That is a function of constitutional conventions, which we received from the United Kingdom. And it also referred to underlying constitutional principles, the ideas of federalism, of democracy, of the protection of minorities, and a few others, which in a sense should always inform how we interpret and apply the written instruments. The court brought together all of these considerations in arriving at the decision that it did. It was an exercise in statecraft, in a sense, as to the secession question, and it was also a masterclass, if I can put it this way, in the Canadian Constitution in all of its manifestations.
It's very interesting to see the law from a perspective of one of the justices, still keeping in mind that you are a group. How do you see the role of the Supreme Court? Because you're not just a justice, you are the court. How do you see that role?
Well, once upon a time, long ago, I was a trial judge, and you sit alone. Sometimes you have a jury, but you sit as a judge alone. And there are great advantages to that. Then I went to the Court of Appeal, and I had two colleagues. And initially I was concerned, oh gosh, I have to find a way to agree with the other two, or at least deal with them. What I found at the Court of Appeal was 3 heads were better than 1. And that, in fact, it was through the discussion and deliberation and the cooperative drafting of reasons for decision, it was a better product. When you have 9, there is increased wisdom, and availing of the wisdom of your 8 colleagues and contributing to their efforts when they're writing is really quite fundamental to the institution. And so a kind of a collaboration, a bona fide, a collegiality, it smooths out the particular preferences of individuals, and I think helps to focus on the larger goals and principles by which we are to direct ourselves.
When your colleagues read your dissent, they still go for lunch with you?
Oh, always. Always, yes.
Thank you very much, Justice Rowe.
A pleasure.
Thank you for joining us for this episode of Shaping Canada, 150 Years of Landmark Decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Cazirer, Suzanne Côté, Andromache Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Bakin, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Leperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.